including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello, everyone. You're welcome to Hanging Out with BWF Solicitors. My sincere apologies for the delay. We have some few technical issues. But hey, fortunately, we've been able to resolve it. Please accept our apologies. I hope you are all keeping well. What a lovely day we have here in the UK, London. And I hope you are also having a very lovely weather wherever you are. We thank you so much for taking time out of your busy schedule to join us today. Please share this live broadcast. I believe that it will be of benefit to someone in your contacts. If you want to contribute to this program, you can do so on all our social media handles, especially Facebook and YouTube at BWF Solicitors. We would love to hear from you. Today's topic is how to apply for indefinite leave to remain under the 5-year route or 10-year route. With me today is, as usual, Mrs. Eunice Champong, a solicitor and also a partner at BWF Solicitors. BWF Solicitors is one of the top 3 law firms in London. They have been awarded so many awards. They specialize in immigration and nationality, Ghana law and practice, family law, dispute resolutions, and many more. Lawyer Eunice, you're welcome to today's program.
Hi, Vicky. How are you?
Oh, I'm good. And you?
I'm doing well by God's grace. I'm loving the jumper. It really suits you.
Yes, I know. I just wanted to brighten people's, faces today.
Of course.
I'm hoping to create a positive impact.
And it's going to be effect.
Yes, I think I've achieved it with you because
Of
the
course.
smiles, I mean, it's so infectious.
Yes, I'm loving it. I'm actually loving it. So it's good that
Thank you.
you came with a bright yellow jumper today.
Exactly.
I hope your week
Exactly.
has been good as well.
Yeah, it has been amazing. Yeah, yeah, yeah. You know, it's been the same throughout the week, but I believe that it I wasn't as busy as you, if I should say. Yes.
I
Yes.
know. I
Yes.
know.
Yes. I know that even though you had a very busy week, of course you have some news of what happened during the week. If you don't mind sharing with us before we, go into
To
today's
the
topic.
topic. Okay, so the updates mainly were to do with our immigration laws changing. And last week I was mentioning the fact that there has been some changes to do with our immigration laws. And from time to time, they do make these changes and it helps because, of course, once things are changing and um, people are able to access the law in the way that we are sharing on Facebook or YouTube or whichever social media platform you are watching it from, then people are being informed as to the best routes to take. And the last time I was mentioning the fact that when it comes to our current immigration laws, there have been a certain number of changes. Obviously, there
Yeah.
are so many changes, but we mentioned a few, which included the fact that if somebody were to make an application based on their private life, either a child who has lived in this country for a continuous period of 7 years, or a person who has lived in this country for half of their lives, they are now over the age of 18 but are between the ages of 18 to 25, and
Mm,
they can show that when they came or when they obviously obtained their leave to remain, they have lived or they have attained that leave to remain for a period of 5 years. They can then go on and apply for indefinite leave to remain after that 5 year period.
okay.
If that person was a child who was born in the UK, so that child has lived there since birth and they've now attained the age of 7, and
Mm,
their parent puts in an application for them, it will be an application for indefinite leave to remain. So they can be granted indefinite leave to remain right away in terms of that application. So it's great news for those children, especially um, for the fact that we know that any application made under our paragraph 276 is usually on a 10-year route. So for them to now say that you can apply for indefinite leave straight away or after a period of 5 years is great news for those children who are applying under those routes. And then you have, for instance, those that are saying that they had EEA applications made, and since the concession that introduced the fact that even if you made an application under the EEA family permit route, we will now issue you EUSS, which is EU Settlement Scheme grant, I
mm,
mean, family permit for that same extended family member, for instance, or that family member who made the application before the 30th of June 2021 deadline. And so now it's been incorporated into the law so that now anybody who has previously made that application under the EA family permit rule can now be issued with that EUSS or EU settlement scheme family permit. And I think that it is also key to also mention that when it comes to our family and divorce areas as well, this has been long overdue. I think that the courts are now in sync with what the government has introduced as the fact that we don't need the the parties who are going to get divorced to now have a fault or a reason to get a divorce. And so they call it the no fault divorce. And so you're not blaming one person for the breakup, but you are just saying things are not working out between the two of us. Let's end things. And so the no fault divorce has now been introduced. And I think a lot of couples, especially those who are expecting the other party to consent to the divorce petition, they wouldn't need that consent to go through before the divorce procedure is finalized. So I think that helps a lot of people who usually have to go through the long procedure of
Mm.
now getting the other party to sign the documents, or having served the other party with the petition from the court, they haven't received acknowledgement, and now you have to have process service come in and issue that affidavit to say that yes, they have served that person before the court can then go on and process the divorce, because now it is deemed that that person has been served with those documents. So I think that takes away all of that long process and makes it a bit easier for couples where the other party is very, should I say, stubborn and doesn't want to consent to the divorce proceeding. So that is in regards to the no for divorce applications as well. So just a few updates for today, and then hopefully we'll get some more during the coming week.
Oh, okay. All right. Thank you so much, Laura Eunice. Today's topic, how to apply for indefinite leave to remain under the 5-year route or 10-year route. Now, Laura Eunice, who is eligible to apply for the indefinite leave to remain?
So a lot of people get excited when they are applying for indefinite leave to remain, because they know that it is the end of the long haul. So they are looking forward to making that application, and then hopefully applying for naturalization as a British citizen. So
Yeah.
some people sometimes get ahead of themselves, if I can put it that way, and then they make the application, for instance, because they've completed 5 year must be eligible for indefinite leave.
Mm.
Assume that because maybe they apply for indefinite leave to remain after completing 2.5 years twice. But it's not the case, because our immigration rules and Appendix FM is quite clear as to who can gain indefinite leave to remain, either under the 5 year route or the 10-year route. And it says
Okay.
that you have to have completed a period of 30 months, which would have been a period of either 60 months, 60 months, as I was saying, or 120 months, to be able to be eligible to apply for indefinite leave to remain. So 60 months is the 5 year period, and 120 months is the 10-year period. So if you haven't completed a continuous period of, let's say, 6 months, six, I was saying something before my phone interrupted, sorry. So
Okay.
if you haven't completed a continuous period of, let's say, 5 years on the 5 year route, so you are looking at 2.5 years given to you on the 5 year route, and another 2.5 years given to you on the 5 year route to complete the 5 year route period.
So you renew twice, isn't it?
Yes, on the 5 year route, because
Okay.
sometimes the Home Office will say, we have given you a period of 30 months on the 10-year route, which is separate to somebody who is on the 5 year route. So if, for instance, you were given a period of 2.5 years, which is 30 months on the 5 year route, and then you were granted again 2.5 years on the 5 year route, then
Yeah.
after that 5 year period, you will be eligible to apply for indefinite leave to remain. But if you, for instance, were given 30 months on the 10-year route or 30 months outside the immigration rules, and then the next application you made, you were given another 30 months on the 5 year route, the
Hmm.
next application will be another application for leave to remain on the 5 year route, not indefinite leave to remain. So a lot of people get confused as to the fact that they are not yet eligible to apply because they're thinking, well, I've done 2.5 the first time and I've done another 2.5, so I must be eligible. But it's not like done that way. You have to complete 2.5 years or 30 months on a particular route, either the 5 year route or the 10-year route, to be able to apply
Mhm.
for indefinite leave to remain after that period. So whether you're a parent or a partner under Appendix FM, you are going to be making that application because you have completed that continuous period under either the 5 year route or the 10-year route. And so it's important that we bear in mind that it is not just completing 5 years or it is not just completing 10 years. It has to be that continuous period on that particular route to be able to make that application as a parent or as a partner.
Okay. All right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors, your Saturday legal immigration program. You can send in your questions, and Lawyer Eunice will be able to answer your questions. Please share to all your contacts, loved ones, and colleagues, relatives. We'd love to hear from you. Send in your questions. You are watching us live on Facebook, YouTube. Lawyer Eunice, what are the requirements to applying as a parent then?
So for those that are parents, when we look at Appendix FM of our immigration rules, it states that as a parent of a child who is either British or has lived in the UK for a continuous period of 7 years, or a child of a person who has EU settlement, limited leave to remain, or settled status, you can make the application if you meet certain requirements. So you must be able to show, like I said, that you have completed a continuous period of either 60 months or 120 months leave to remain, and it has to be on that particular route. So if you have completed a period of 60 months on the 5 year route, that is to say, you have completed 2.5 years on the 5 year route and another 2.5 years on the 5 year route, which makes 10, I mean, 5 years, then you can go ahead and say that you are now eligible to make that application. But you have to also meet the eligibility requirement. So you have to be able to show that you have a relationship with that child. You have to show that your immigration status was still extant at the time of your leave. You have to be able to show that you've completed the English language test at a level B1. And then you also have to show that you've done the Life in the UK test as well. And then, of course, you have to show that you meet the maintenance requirement. So, as a parent, you don't have to meet the financial requirement like the partners, but you have to be able to show that if your income, which is your income after tax, if your income is considered and your rent is taken out and your council tax as well is taken out, then whatever you have left, which is the money that you would use, will be able to maintain you and that child or those children.
Yeah.
So if they look at the income support rate in this country, usually each child will get about 66 pounds 80 for the week, and then the parent for that child. So if it's a single parent household, then the parent for that child will get about £74, 20 for the week. So if we are going by that, then we want to know, or the Home Office would like to know, that your income for that week will be equivalent to that income support rate. And so they'll also want to know that you have accommodation which is suitable. So either that you are renting a place, or you own your own place, or you are lodging somewhere where there is enough room for you and
Yeah.
the child or those children. So if you are able to meet all of those other requirements, then you can go ahead and say that you are making the application as a parent who has completed 2.5 years. Maybe you've done three um, renewals. So maybe you were on the 10-year route first of all, you renewed, and then you were put on the 5-year route. Then you renewed it again, and you were put on the 5-year route again. So you are now making an application to say that you've completed 60 months. So even though you've done 7.5 years, you are saying that you've completed 60 months, which is 5 years on the 5-year route. And so you're applying for indefinite leave to remain.
Amen.
Whereas somebody who is on the 10-year route will be saying that, well, I've been able to complete that 120-month period. So as a parent, I was given 2.5 years, and I've completed it on that 10-year route. And therefore, I'm making an application for indefinite leave to remain. For some parents, it might be that they made the application for renewal, and it has been with the Home Office for a very long period of time. So maybe 2 years it took for the Home Office to make a decision. And so they're thinking, if it was 2 years for them to make a decision, then that time must count towards something. So once that person is able to say, it took you 2 years to make a decision on my renewal, but
Yeah.
I already had leave extant. So my leave was still valid when I made the application. So under our section 3C, we know that a person's leave will still continue as
Mm.
before, even if they made the application whilst their leave was still extant, or whilst their leave had not expired. So that person will still be able to argue that because my leave was continuing at the time that you were making that decision, I can still count those years towards maybe my 10-year leave to remain. So if they initially had 2.5 years leave to remain, let's say in 2014, and it was granted to them in June of 2014, they will be eligible to apply for indefinite leave to remain in June of 2024. So they don't have to complete that leave to remain that will be granted to them on the fourth run. They can make the application once their 10-year period is up. So that is
Oh,
also for those on the 10-year route. Yeah.
okay. Right. So, the requirements
Yeah.
is the partner, the parent route different from the partner route when it comes to requirements, or they are the same?
In terms of the requirements, they are different in the sense that when it comes to
Mm.
partners, the financial requirement is different. I think that's the only difference in terms of parent and partner.
Mm.
So the main difference will be the partner
Mm.
route. I mean, the financial requirements that they will have to meet in terms of either they are able to show that they meet the 18,600, or they are self-employed, and so maybe they meet that 18,600 and they have even more. So the only difference will be the financial part.
All right. Okay. Right. I've got Suleiman. Is a parent, and was initially given 2.5 years to remain on the 10-year route. The second one was on the 5-year route. Then COVID came. Then Suleiman's hours was reduced and was granted said he was granted third leave on the 10-year route. He says, I don't mind if I'm put on the 10-year route for my next leave to remain. Will I be applying for indefinite on the 10-year route?
Okay. So in terms of what he's saying, when it comes to the leave to remain that way, you have been granted 2.5 years on the 10-year route, first of all. And then secondly, when you were making the renewal, they said, well, you meet all of the other requirements, so let's put you on the 5-year route. And now you're making another application on the 10-year route because obviously COVID came and a lot of people were affected by the fact that their jobs had to cut them off basically, or they had reduced hours. And for some people, they were furloughed. And so that was one good thing that they had. So if you are saying that because of the COVID, you've now been put on the 10-year route, then it means that when you have to go for the fourth one, you will be going for another 2.5 years on the 10-year route. But when it comes to our indefinite leave to remain requirements, is mentioned specifically that it has to be either a continuous period of 60 months or 120 months. So here is somebody who's done 2.5 on the 10-year route, another two and a
Yeah.
half on the 5-year route, and then another 2.5 on the 10-year route. There isn't that continuity on one particular route. So they are going to say that because he hasn't had that continuous period on either route, then he's not eligible to apply for leave to remain on either the 5-year route or the 10-year route, because they are going to say to him specifically, you first had 2.5 on the 10-year route, and then another 2.5 on the 5-year route.
Yeah. Yeah.
But because you haven't completed a continuous period on either route, we will not be able, however, has an alternative. So we thank God that the immigration rules is not just limited in that way. So he has an
Mm.
alternative under paragraph 276B, where it talks about showing lawful residence. So if you're able to show a continuous period of residence over a period of 10 years, then you can make an application for indefinite leave to remain. So that is the alternative that he will have in terms of making such an application,
Okay.
because they would tell you it has to be over the 5-year route or over the 10-year route. So because it
Okay.
is not in one particular route, or he hasn't completed a continuous period of 60 months or 120 months on the 5-year route or the 10-year route, he cannot make an application under Appendix FM of our immigration rules.
Okay. All right. Gary says, good afternoon. I have completed 2.5 years, which was granted to me when I was entering the
Can you hear
UK.
me?
Yes, I can hear you. Can you hear me, Laura Eunice? Can you hear me, Laura Eunice? Can you hear me, Laura Eunice? Yes. Can you hear me, Laura Eunice?
I can hear you now.
Okay, thank you. Yes, I've got Gary who sent in a question. He says, I've completed 2.5 years, which was granted to me when I was entering the UK. I was initially refused to enter and went for appeal. The decision was allowed outside the rules and was later issued with my visa to join my wife and children. I applied for another 2.5 years and it was granted to me on the 5 year route. Before that, before that leave expired, I applied for indefinite leave to remain. Was I right to do so?
Okay, so in terms of this, um, unfortunately, it will be
Hmm.
a no because
Oh,
what
wow.
they,
Okay.
yeah, so so in terms of Gary's question, what they're saying is if you applied for leave to remain, and for instance, you were given that leave to remain on a 10-year route,
Mm,
and having therefore gone ahead and then said, now I would like further leave to remain on the 5-year route. Now that you've been granted leave to remain on the 5-year route, it doesn't automatically mean that because you've completed 2.5 years for two rounds, you are
mm,
now eligible to apply on the third go, because
mhm.
people think that because it's the 5-year route, so it means I have to complete 2.5 years twice and then I can apply for indefinite leave to remain. But you have to be able to recognize the route you're on. So if you were initially granted 2.5 years outside the immigration rules, and then you were
Yeah,
granted 2.5 on the 5-year route, that means that you have to complete another 2.5 year period on the 5-year route to be eligible to apply for indefinite leave to remain. So it
remain. Okay.
is important that he now completes another period of 2.5 years
Mm.
before he can apply for indefinite leave to remain. So it's unfortunate that he thought that because he's completed 2.5 years twice, he was eligible. It has to be on a particular route. So if he hasn't completed 5 years on the 5-year route, he will not be eligible to apply for
Okay.
indefinite leave to remain. Yeah.
Okay. Okay. All right. Great. Um, right. I've got this question. I think the person says, I shouldn't mention the name. I was first granted 2.5 years on the 10-year route, and the second and a half years were granted on the 5-year route. I applied and was granted my third leave on the 10-year route because I didn't have an ESOL certificate, which was at the level A2. I went ahead to complete the ESOL test at the correct level and asked my lawyer to submit a pre action protocol letter about a month after their decision. They did not give a favorable response, and I decided to reapply for leave some days after the 5-year route and was granted. I have applied for the ILR and I'm now being asked consent to being put on a 5-year route again since the third leave granted on the 10-year route. Can that be right?
Okay, so let's break it down. So he's saying that he he was granted 2.5 years on the 10-year route.
Yes,
Then he was granted another 2.5 years
on the
on the
5-year
5 year.
route. Yes,
Then he applied for 2.5 years and he was put again on the 10-year route
10-year
because
route.
he didn't complete the
The ISO.
ESOL test at the right level.
Yes.
And because he didn't complete the ISO at the right level, he decided to do the test again and then asked for the Home Office to review that their decision and then put him back on the 5-year route. But
Mm.
he didn't get a favorable answer, so he decided to make an application and be put on the 5-year route, and
Mm-hmm.
he now wants to make the application. He says he's made the application, and the Home Office have contacted him about
Mm-hmm.
his indefinite leave to remain application. Okay,
Mm-hmm.
so if I am to look at this, I think that the third leave to remain, he was expecting that he would have been put on the 5-year route, but it
Yeah.
didn't happen that way because of his English language test. And um, he was hoping that they will review the decision because he's now got it anyway. So why would they not give him the 2.5 on the 5-year route? I mean, now the Home Office are very proactive when it comes to using their discretion. Um, Prior, sometimes they will not have a certain document, and then they will just make a decision that to refuse, and then to put you on the 10-year route. But there are some caseworkers that were still proactive back then who would have asked for the documents to be presented if they thought, well, if you've been able to meet the previous level, then you must be able to meet the new level that we are requesting. So bear in mind that when you are applying on the either the parent route or the partner route, they do require that at least if you are now making your second application and you haven't previously done the ISOL, you should be able to show that you've done it at a level A1. But if you have previously done an ISOL test and you use that with an application, then you should be able to show that you have met the ISOL requirement at a level A2. So
Mm.
if prior to doing the third one, you did a level A1 ISOL, this time round they expect you to meet a level A2. So that's what you have to be able to meet.
Mm.
So once you are able to meet that requirement, then they can process that you've met all the requirements. But in this case, I think that the caseworker was not so nice. They didn't want to use their discretion, so they just went ahead to put him on the 10-year route
Mm.
because he still has leave to remain anyway. And he being very optimistic thinks that after doing the exam, they should have some heart or compassion to put him back on the 5-year route. But they didn't do that. And I think if he had done the test within 14 days, then we could have said that they should reconsider the application. It is within 14 days of his leave, and therefore they can consider this English language test that he's done and put him on that 5-year route. But he says it was a month. So if it was about a month after their decision, then unfortunately, they would go ahead to say that you don't meet that continuous period requirement. And so unfortunately, they will not consider putting you back on that um, route, which is the 5-year route that he applied for. So even though he's met the requirement, they've already put him on the 10-year route. So that means that unfortunately, he has completed
Mm.
two different routes. And so he was not going to be eligible to apply for indefinite leave to remain after that third, or should I say fourth round of 2.5 years leave. So when it comes to making the application, because he has made the application based on his indefinite leave to remain, I'm sure they're going to say you meet the requirements to be put on the 5-year route. So they will put him back on the 5-year route. And then after that period, he can then apply for indefinite leave to remain as a parent or partner, whichever one he is, to then go ahead and get his should I say leave without restriction. It's unfortunate. I really feel like um situations like this is very It's very difficult. You think they would have some mercy, but they didn't. So it's unfortunate.
Mm. Oh, okay. All right. I think we are done with the questions for now.
Okay.
I believe if you can quickly round up and leave your details for the benefit of those who would like to contact you for further assistance.
I think there was one on Facebook who says, "Good
Oh,
afternoon.
is it? Okay.
If one of the parent is having a UK-based master's degree qualification, can the other parent benefit from it to qualify on the 5-year route? Also, is it possible to qualify for 5-year route to indefinite leave to remain from the first application?" So let's take the first question first.
Okay.
So he has a master's degree. He's thinking that the other parent should be able to benefit. No, because it is not the other parent's degree. So it is done on an individual basis. If the other parent does not have a degree and they can do the ISO test, then they can go ahead and complete the ISO at the right level to be able to apply on the 5-year route. But
Mm,
unfortunately, just because one parent has it doesn't mean that the other parents will be able to benefit from that ISO um, test.
okay.
And then again, he says that um, is it possible to qualify for 5 years um, to qualify for 5-year route to indefinite leave to remain from the first application. So
Yeah.
it depends. If the first application you made, you previously were granted leave maybe outside of the rules because maybe you didn't meet all of the requirements. And so they
Mm,
decided to put you on the 10-year route.
mm,
Once you have been put on the 10-year route, that means that that is the route that they assume you will be able to complete until you have met all of the 10 years. They will not make you eligible to apply for indefinite leave to remain. But if,
okay.
let's say, you've completed 2.5 years and you were put on the 10-year route, but then the next 2.5 years you were able to meet all of the requirements. So you are saying to the caseworker, now I've met all of the eligibility requirements, of I've met all of the suitability requirements. Can you
Mm,
now put me on the 5-year route? Once you are able to meet all of the requirements, they will put you on the 5-year route, which is two
okay.
and a half years. But it doesn't mean that you can complete that 5-year period just because the second one was given to you on the 5-year route. So you have
Route.
to complete 2.5 years on
Mm-hmm.
that 5-year route. So the first 2.5, which was given to you on the 5-year route, that is one. You have to complete another 2.5 years on the 5-year route to be able to be eligible to apply for indefinite leave to remain um,
Remain.
the third time round. So you may have completed 2.5 years the first time, but if it was not on the 5-year route, then you would not be able to apply for indefinite leave to remain. But for somebody, for instance, who came into the UK as a spouse, let's say that they were granted 2.5 years leave, there was no appeal, they got it straight away because they met all of the requirements. So they were given 2.5-year leave. Usually, we assume that the 2.5-year leave they were granted is on the 5-year route because they met all the
Okay.
requirements. So their next application for 2.5 years will hopefully be under the 5-year route if they are able to meet all the requirements again. Then after a 5-year period, they can apply for indefinite. But if their second leave to remain is not um, granted on the 5-year route, let's say that they didn't know they were supposed to complete a higher level of ISO, so they were put back on the 10-year route, then unfortunately, after the 5 years, they will not be able to apply for indefinite leave to
Okay.
remain. They will apply again for another 2.5 years. So
Okay.
a lot of people do get confused because their assumption is I must complete 5 years to be able to apply for indefinite. But if you do not meet all of the requirements, they will put you on the 10-year route. So
Oh,
we have to be careful about that because I keep getting those questions time and time again. And so
yeah.
I thought it will be better to explain on this platform so people have the understanding as to why it is not immediately after 5 years, because they do look at the routes, and if you haven't completed on the right route, they cannot grant you indefinite leave to remain
Interesting.
after that 5-year period.
Mm.
Yeah, yeah.
All right.
Okay.
Thank you for that. So, if there are no other questions, probably we can quickly, if you can summarize everything discussed today, and also your details for anyone who would like to contact you for further assistance.
Thank you. So, I know today was a topic that I know most people would have been very interested in. Um, Obviously, like we always do, we leave it on our social media platforms for people to go back and listen and then see how best they can help themselves. In terms of this program, we do not just deal with immigration law. As Vicky mentioned at the beginning of the program, we deal with other areas of law, including family law, civil litigation, child arrangement orders, non molestation, um, other areas that some of our lawyers do handle is also housing and then Ghanaian law as well. So, if you do need any information or you do need legal representation in regards to any issues that you may have, then please do not hesitate to contact BWS solicitors on 0208 493 7340. So 0208 493 7340. And our offices are opened from 9:30 a.m. to 6 p.m. from Monday to Friday. Our offices are situated in London. So our address is the fourth floor of Anna House, 214 to 218 Tottenham High Road, London, N15 4NP. So the postcode again is N154NP. And hopefully, if you cannot reach our offices, you can also book for a telephone consultation, because we do telephone consultations and Zoom consultations. My number out of office hours is 075 3581 3910. So 075 3581 3910.
Thank you so much, Laura Eunice. Ladies and gentlemen, mm, the show has to come to an end. We have to stick to time. Um, if you have any further, request, or you need a solicitor to help you with your application, BWF solicitors are there to give you all the support and help. Laura Eunice and her team will be on the standby. She left her details for you to, contact her. Um, like Laura Eunice said, anyone who joined the program in the middle of the show can go back and watch it on YouTube. Laura Eunice, let's take this opportunity to wish all mothers a happy Mother's Day, and until we see you the next time.
Yes.
Yes.
Happy Mother's Day.
Take care. Bye bye.
Bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.